Hello, I am Dr. Sheena Swemmer. I work at the Center for Applied Legal Studies here at Wits University, and I am the head of the Gender Justice Program. So just to give you a brief intro to what CULS is about, because for those who don't know, they often think we're just this entity that sits in the middle of nowhere, which is partially true because we do sit in the middle of nowhere, but so CULS is really very different to what you would ordinarily get at a university in terms of law and law clinics. So universities usually have clinics where they train their law students. So you deal with a lot of direct services. So those are where people are needing legal assistance and you're doing those types of cases for them, the everyday cases. CULS is different, however, because what we do is called strategic litigation. So we don't do the day-to-day cases that individuals approach us with. We take on cases that can significantly change the law and change the way people experience the law in the country. So as being head of the Gender Justice Program here at CULS, my work is really focused on gender-based violence and how it intersects with other rights. This can be things like violence against pregnant women in hospitals. So that's affecting your right, not only your right not to be discriminated against, but also your right in terms of healthcare and services. And then the other area besides the intersection of rights is that I focus specifically and I enjoy the work in relation to sexual offenses, domestic violence, and women in the law, and how violence against women affects them, affects their existence in the world, and affects their existence within the law in the country. So one of the interesting and very significant cases that we are focusing on here at CULS at the Gender Justice Program is the case of a woman, our client, who killed her abusive partner. So this case came to us about 7 years ago, and it had actually strangely just come from an email of someone who had known our client years before and had heard about the incident and that she was now being held as an awaiting trial prisoner. And this person was in like the UK or Germany or something. So it's a very strange way these things come to you. And she had just expressed how much she had enjoyed spending time with the accused, the good relationship they had, and just how heartbroken she was, because the accused wouldn't be able to, our client wouldn't be able to afford legal representation, and she had killed her partner. So we took on the case, and it is one of those, it's these strange things that you get in the country. I mean, you get in the world too, but you get in the country of, it is the most terrifying, most disgusting kind of events that happen, but they become so everyday, especially in relation to women in our country. So you have women who are beaten by their husbands, they're raped by their husbands or their intimate partners, they're emotionally abused by them for years. And now the ordinary part of this is that we ordinarily here in South Africa hear that they've then been killed by their partners. And that's the story we hear every single day in our country because it's so prevalent. I mean, I was at a conference in December and I'd seen the recent one of the recent stats, and I had said to the people in the conference, well, we've been sitting here for 8 hours, 4 dead bodies should be lying there of women who get killed in our country every day, predominantly by their intimate partners. So terrible things happening, women are killed every day, but then we get the case where a woman is lucky enough not to have been killed, but she has killed her aggressor. And we do hear about this every now and then. I mean, it's so unusual for a woman to successfully have been the victor in this kind of fight because of the high rates of femicide we see. But then we also see when women are successful in freeing themselves or escaping and killing him, the legal system doesn't step in with any kind of nuance or understanding. So, and I'll give you some examples from our client's story, but the importance is that these cases of these women who have killed a partner and they've suffered years of abuse have been happening for years. I mean, in our Culls has a little library here, and if you go through the old Culls stuff, as far back as when Prof. Kathy Albertine was at Culls had been working on cases like this. So it was already 20 years that these cases have been coming up, and they have been resulting in predominantly sentencing, to women being sentenced and going to prison, rather than any type of other outcome you could get, especially being acquitted. So this is something that's been there for many years. So we get to the place now where we have this client, we have the situation where the courts have seemingly not responded with any nuance, with any understanding of domestic violence, and we decide it's been years since something which was called the Engelbrecht case. This was one of the few cases where a woman killed her partner, and instead of it being a case where someone acted in, and I'm going to try to make this as easy as possible. When someone acts in self-defense, in law you need two main things. It's proportionality and it's timing. When somebody attacks you, say with a slipper, you can't take out a gun and shoot them. So proportionality, what did you use? What was the attack? But then there is the timing. The attack in terms of our law has to be imminent. It has to be happening right now. And Engelbrecht was a case where a woman had been raped, abused, tortured by her husband for years. I think he had gotten drunk or something, had fallen asleep, and she had taken a bag and tied it around his neck. And he died. And that is the last time our courts just considered what happens in these types of cases where there may be a delay or those types of things. And although they acknowledged that this could still constitute, where there was a delay, could still constitute self-defense, this woman was unsuccessful in reaching that threshold. But a good part about this was she was only sentenced until the standing of the court. So this means the judge says, okay, that's it for today. You may be excused, and she is free to go. So you can see how the sentencing disagrees with the actual charge. They don't think these things are together. And that's where it's been left since like the 19s, the Engelbrecht case. And women are still going to prison, and it's never been moved since then in any real way. So a couple of years ago, our client comes. She had been a victim of violence for many years at the hands of the deceased. There had been rapes, there had been beatings so bad she's miscarried in the past. She's tried to go to the police before. They do the usual thing where they say this is a private issue. And yeah, so the whole normal thing goes on, the whole script of how these things usually happen. Then one night, he tells her she has to come over to his place with him. He locks the door. She doesn't want to have sex. He rapes her. She then wants to try and escape the house and first she tried to use scissors to jimmy open the door, and then she tries to use a knife. He fights her for the knife and he gets stabbed. And like, I'm sure what's happening in your head is you're saying, but this sounds like normal self-defense. This doesn't even sound like delayed or anything. And this is the important thing. Is since Engelbrecht, we've gone backwards. So in these cases, and the stats around this seem to suggest, so from court cases you can trace, is that women are not even successful in self-defense as it stands in our law. So here there's an imminent attack, proportionality. I mean, they were fighting over the thing, so it's not like she even chose the thing. This is established in our law already. and then she gets found guilty and sentenced to 10 years. So we come so far with Engelbrecht. In 10 or 20 years, we just go backwards, and we see that in most of these cases, these women are being found guilty and are being sentenced. But we have self-defense as a defense in our law. Normal self-defense, not working. And that's what happens in this person's case too. So she also, just to highlight kind of this is where intersections of or intersecting things come, and it makes the situation even more apparent, and is that she is denied bail. So she spends, and I mean it's more or less, she spends about 4 years awaiting trial. So if you're denied bail, you will go to the prison and you will await trial until such time as that trial is finalized, unless you're successful in another bail hearing. So she sits 4 years just waiting for it to start. It takes us about another year and a half, 2 years just to do the trial. She spends 6 years. And then she gets sentenced to 10 years. What the magistrate says is not, let me take the 10 years that I've sentenced you to and minus the 6 that you've now spent. The magistrate says, no, I'm taking the full amount, because in certain serious crimes we have like guidelines around sentencing. So let me take let me take the 15 years you should spend, and I'll minus 5 years for the time you've spent. So in other words, in mitigating, because you're allowed to have mitigation of sentence, where arguably the magistrate should have considered the years of abuse. Instead of saying, you have this history of abuse, we've had experts come and speak about it in this court, you can hear the testimony of the client. Instead of saying 10 minus 5 or minus 6, I say, you don't deserve any mitigation in terms of your circumstances, the fact you're a first-time offender, the fact that you have 2 children at home. I'm just going to minus those from the full amount. So you will sit 10 years over and above the time that you have now been sitting. So there's this, and this is common, and it is called double deviance. So this is something that happens in all sorts of jurisdictions, not just South Africa, is women who kill and women who do non-feminine crimes, or crime in general, because women shouldn't commit crime. That's not proper for women to do. They get punished twice. They get punished for doing the crime, but they get punished for being a woman doing the crime, so their sentencing is more significant. So it's something that's traced throughout jurisdictions, is that women can't be murderers, and if they are murderers, we should punish them. And then you get all other kind of patriarchal and problematic things that come in, and it's things like, if we allow this, all women are just going to kill their partners. I mean, so it's kind of funny, because we get the kind of politicized idea of hysteria always being women. And if anyone is hysterical, it's men. And I question why they are so worried about all these women killing them. But there's no proof. There's no kind of evidence to show that any of this would occur in a way that it would make women want to kill men, especially because women are the ones predominantly being killed. So at this point in time, we've been successful in getting leave to appeal for our client. So that means we've convinced a court that on the lowest threshold of evidence, that another set of judges would decide differently. And we are now permitted to apply for an appeal to the High Court. And let me say the disappointing things first, and then maybe end with the more, maybe end on a high note. So this is a bittersweet thing. The client at this point, I think, only has 2 years before she can apply for parole early, to be allowed out early. Finalizing a case in the High Court might take 1.5 years. And what is the value of having appealed? So when we're saying appeal, is another court might decide differently, both about your conviction and your sentence. So where someone shouldn't even have been convicted, what is you've now spent an entire time. You've almost spent your entire, your entire sentence being behind bars. How is that fixed now that you've been acquitted by a superior court? So all these things really build up on each other. You start to see how incredibly important the criminal justice system is as a token of hope for people, as a light for people. They want to see the system work. When it doesn't work, which we're not working in the best way, like with women who kill, we also see how the criminal justice system just keeps failing. So how long your trial will take, the fact that you'll be sentenced and then it'll take so long for your appeal to get through that you would have spent your entire time there anyway. So you do start seeing the huge errors or the huge problems with the criminal justice system, along with its potential for good. And that's kind of the situation the client is in. And it is important that we argue should be acquitted and try to have, try to get as much justice for her as we can in a system that doesn't work. So this is coming back to the beginning to close this off nicely, I think. The point of CALS is really about attempting to find and help find justice for people. It might be justice for the various violations they've experienced. And our role is in the courts. Our role is in the courts and the community, but our role revolves around law. We're here, if there's a pathway to justice, we're here to clean out all the debris and things of law. So where law is stopping you from getting to justice at the end, that's our job. So we must clean that for you. So we can't do the other things. So we can't make the world less patriarchal and all those. So with this client, and bearing in mind all the challenges and things that she faces, we are looking at and supporting her and trying to get get her acquitted, but we're trying to do more than that insofar as we are wanting to create a strategic project so that it helps her and others. And of course the acquittal and things are important to her, but her and others insofar as what are the ways that we can clear out the legal system to assist these women. And because you base things on the facts of your own case, we are not dealing with trying to change the law or further the law around whether someone is responding to an immediate attack or if it's delayed. We're looking at sentencing of women who have unfortunately been sentenced to killing their abusive partner. And what we are suggesting is that where you have mandatory or you have guidelines, they're not guidelines. They do create a duty on magistrates to consider certain minimum sentencing for serious crimes. Where we've got these things where your judicial officers are asked to specifically consider something in terms of legislation, why can't we have them have an obligation to consider the history in these types of situations? So where you are encountering, may it be intimate partner violence, and you would have it whether it's a man or a woman, there should be a consideration of the abuse that had been suffered for years. There should be there should be a focus on the attempts you made to report, the failures of the state to listen to you, the times you've tried to leave, all those things. And although you've been found guilty of murder in this instance, because we have to deal with our client's case, you should have a mitigation. And this mitigation should be quite a big one. We wouldn't step into the realm of saying what judicial officers should give, but where we say for certain types of serious offences you should give higher rates or higher sentences, we want it to be the mitigation of that. So there should be a significant reduction in a sentence if you are sentencing this person going forward. So ultimately what we're trying to achieve is a constitutional challenge, saying that the law doesn't apply equally to everyone, especially where you have a woman acting in self-defense and she's also had years of abuse. That doesn't serve them. The law is not helping them the way the law helps people who may not have experienced that. And so we need a significant mitigation of their sentence. And that's where we're hoping to go with this.